Right, as promised, we're catching up on an important court case. The Council for the Advancement of the South African Constitution, CASAC, and other pressure groups earlier went to court to try and stop the Zulu King from charging his own people rent. Last year, the Ingonyama Trust, of which the King is the sole trustee, you'll remember, published adverts in various KZN newspapers inviting holders of permission to occupy land rights, which are informal rights, to upgrade those into long-term leases. But CASAC and the other applicants say that will affect the security of the people involved. The Ingonyama Trust was established in 1994 to hold all the land that previously belonged to the KwaZulu government for the benefit of communities living on the land, and that accounts for about 60% of rural KwaZulu-Natal. But it has become a political hot potato, with many accusing the Zulu King of using the law to exploit his own people. To discuss, we're joined from Cape Town by the Executive Secretary for CASAC, that's Lawson Naidoo. Thank you for being with us, Lawson. Why does it make people vulnerable, firstly, to sign these long-term leases?
Well, the fundamental issue, Francis, is that the long-term leases that people are being forced to sign is a weakening of their existing customary law rights, which are guaranteed in terms of their permission to occupy rights that they currently hold. Those rights that they currently hold are rights that they hold in perpetuity, which means that it's a right forever and can be passed on from generation to generation, as it has been for over many centuries and through many generations of people who've occupied that land. This move by the Ingonyama Trust to seek to force people to sign lease agreements means that their rights are weakened, because they will now only have rights for a 40-year period in terms of that lease. It may be renewed, but there are conditions attached to those leases, which include the fact that for the very first time, people are required to pay rent for residential land that falls under the auspices of the Ingonyama Trust. In terms of Zulu customary law, the payment of rent on such land is a foreign concept and has never been implemented before. There's also an automatic 10% escalation annually on this leasehold figure. And many of the people who are affected by this are poor and are unable to afford the rents that are now being demanded by the Ingonyama Trust.
So you see this as a further move by the King to take land that should be for a people and make it de facto his own?
Well, exactly. The trust is acting in a way as it is the full beneficial owner of the land, whereas it actually only holds that land in trust, as you said earlier, on behalf and for the benefit of the people and the communities that occupy that land. And the King is required as the sole trustee, in terms of the trust deed that sets up the Ingonyama Trust, to act in the best interests of those people. This can hardly be said to be acting in the interests of the people, because, as I say, it weakens their rights to land. And the notion is being sold to people on the basis that they will be able to use these leasehold agreements to raise funds from banks and so on. But that's a weakening of their rights, and it's only likely to create more financial strain for those very people who ought to be benefiting from this.
And incredibly, apparently women cannot sign these rental agreements.
Well, that's another issue, that the discrimination and the failure to respect the equality provisions of the Constitution, again, flies in the face of constitutional rights of people living on Ingonyama Trust land. It's also the fact that when people sign these lease agreements, the person that signs it has the right to that leasehold agreement, and other members of that family and extended families who often occupy the same piece of land will no longer have the protection that they currently had under customary law. So it really is a weakening of rights and taking away of rights from many people, and in particular vulnerable women in KZN.
Lawson, aren't you dealing with a smaller issue if we accept that the bigger issue is that this entire structure is codified in law? Shouldn't you be going to Parliament and trying to push a change of law to give these people full property rights? Then, yes, you can go and use it to buy things and you've got an asset.
Francis, the issue here is that many of the residents and others have sought to approach both the MEC in KwaZulu-Natal, as well as the Minister for Land Reform and Rural Development, in fact, to do what they are required to do in terms of the Constitution and legislation, which is to actually upgrade the rights and formalize it in terms of full ownership rights over that land. Government has failed to do so. When the Ingonyama Trust was called before Parliament earlier this year, and they were told by Parliament to desist from implementing these lease arrangements, they simply ignored Parliament and have been acting with impunity in clear breach of the Constitution and the law. So we really, at this point in time, are left with no option but to seek redress in the courts, because the Ingonyama Trust sees itself as being above the law and not accountable to anyone.
Well, the ANC, even the president, I think, has suggested that that land won't be part of the whole land redistribution, restitution debate. Do you see that as some sort of unwarranted political protection?
Well, I think that's a wholly separate issue. I think the president's comments were related to the debate around expropriation without compensation, and I think the point that was being made there was that the land would not be expropriated and taken away from the people that currently occupy it. And this is in clear distinction to what we're seeking to do, which is actually to strengthen and entrench the rights of the people who currently reside on that land that falls under the custody of the Ingonyama Trust.
Where's the case right now? When do you expect movement?
Well, our application was lodged last week, and we brought the application in conjunction with the Rural Women's Network in KwaZulu-Natal, as well as 7 individual applicants who have been adversely affected by the imposition of these lease arrangements in terms of being asked to pay rent which they can ill afford. So the application was brought last week. We will obviously await directions from the court as to how the case will proceed, what the timeframes are for the various respondents, which includes the trust, the board of the trust, the minister and the MEC, to respond to our application. And in due course, we anticipate that the High Court in Pietermaritzburg will set the date for a hearing if the matter is going to be opposed.
And that means exactly what? A win means exactly what for the people right now who may have already signed leases, picking up from those ads?
Well, the primary relief that we're seeking is to set aside those lease arrangements that have already been put in place. We believe that this has been done unfairly and unlawfully, because in many cases people were being forced to sign these leases on the basis that if they didn't sign it, they would be required to vacate their land. So they were signing these leases under false pretenses. They were not informed that they would suddenly have to start paying rent and so on. So, our first priority is to set aside those lease agreements and restore people to the previous customary rights that they held, which, as I say, is much stronger in law, and to ensure that the Ingonyama Trust repays to those individuals any monies that have been paid over to them so far.
Lawson, before we let you go, on a completely different issue, I think CASAC has been one of the organizations pushing for former President Jacob Zuma to pay his legal fees, a recent victory. Where does that leave the matter, and do you think that that money can ultimately be retrieved?
Well, in terms of the judgment of the High Court on Friday last week, which refused the former president leave to appeal against the personal cost order that was awarded against him in the state capture review case, the president would have about 2 weeks in order to decide whether he's going to appeal that. We certainly believe that on the basis of the judgment last week, that there's very little prospects of appealing to the Supreme Court of Appeal or to the Constitutional Court for leave to appeal. So, we hope that the president, or the former president, will start making arrangements to pay those legal fees that were incurred in what was a very wasteful exercise, and which had the impact ultimately of delaying the launch of the state capture inquiry by well over a year.
Do you think he has the money?
Well, that's a problem for Mr. Zuma to figure out.
All right, thank you very much. That was the Executive Secretary for the Council for the Advancement of the South African Constitution.